Hey guys, welcome to today's video. First, we're off to Michigan, where a defendant manages to blow his plea deal by forgetting he'd been drinking before getting behind the wheel. Then, we head down to Florida for some classic Florida man antics you won't want to miss. All right, let's get into it.
Ian McLean, turn on your camera. This is 251616 SD, the people versus Ian McLean.
Morning, Your Honor. James Gazicki on behalf of Mr. McLean. He's going to plead guilty to the reduced charge of operating while intoxicated, first offense. And Your Honor, he had a blood alcohol content of 0.168. And also we can cancel the jury trial on November 7th.
Okay, and are you stipulating to that blood draw result for purposes of the plea?
Yes, Your Honor.
All right, Mr. McLean, tell me your first and last name.
First name Ian, I-A-N, last name's McLean, M-C-C-L-A-I-N.
All right, Mr. McLean, you understand you're being offered a plea reduction down to an operating while intoxicated first offense. That's a misdemeanor. It's punishable by up to 93 days in jail, a fine of up to $500, plus statutory costs and court costs and statutory and court costs. Do you understand that?
Yes, I do.
All right, and up to 360 hours of community service, and 6 points on your license. Understood?
Yep.
Mr. McLean, did you go over your constitutional rights with your attorney that are outlined on this advice of rights form?
Yes, I did.
Did you understand your rights?
Yes.
All right, and did you give your attorney permission to sign your name on this form?
Yes, I did.
Understand that if you enter this plea, sir, that you'll be waiving the trial rights listed on that form. There will be no trial of any kind. Do you understand that?
Yes, I do.
All right, and you understand that if you're currently on probation or parole and you enter a plea of guilty, it could be a violation of your conditions?
I am not under anything of any kind of legal results at all for anything.
All right, I have to ask you all these questions. I just need to make sure you know. Sir, you understand if you're not a citizen of the United States and you enter a plea of guilty, it could have immigration consequences up to deportation.
I am a citizen of the United States, born and raised here.
All right. Sir, knowing all of that, how do you plead to the charge of operating while intoxicated first offense?
Well,
guilty or not guilty? Guilty or not guilty?
I guess guilty.
That's not how it works. When entering a plea, you're either guilty or not guilty. There's no guessing involved. If you agree that your actions meet the elements for conviction, you plead guilty, and then either you or your lawyer argues for the appropriate level of punishment.
Well, I don't want you to guess. I want you to know. Has anyone forced you to? What?
No, I was intoxicated. Yes, I was. So yes, I believe I am guilty.
All right. Has anyone forced you to get you to plea?
Nope.
Has anyone promised you anything other than the plea agreement to get you to plea?
Nope.
Are you pleading guilty of your own free will?
At this point, yes.
Well, what does that mean at this point? Yes. I mean, it's a yes or no question, so I can't accept a plea if you're not voluntarily pleading. Do you understand?
I do not feel I'm guilty. I was in a rush to go see my daughter. I forgot that I was drinking. I left my home to defuse the situation with my ex-wife. And
sir,
for the last
were you drunk and were you driving a car on a public roadway? I mean, that's the thing. Like what you're telling me, you just confessed. Basically, I mean, I don't know how you forget you're drunk, but you just told me I don't feel I'm guilty, but I was drinking. I forgot I was drinking, and then I got in a car and drove somewhere.
No, okay. Let me rephrase this. I forgot that I had drank the night before because I fell asleep in my vehicle around the corner to defuse the situation with my wife. The police officer abruptly woke me up, told me my daughter was running around naked outside, and told me to get home. I drove directly home 1 block away from my house. to go make sure my daughter was all right. I was not, how do I say this?
I don't
was
know.
more
I'm
concerned
excited
about-
to hear it though. Go
I
ahead.
was more concerned about my daughter than anything else. She was 3 years old at
Sir,
the time.
but I
and she
mean,
was
there's
outside.
not an extenuating you had a .168. I don't know what the heck you drank the night before, but you were twice the legal limit. I mean, the police report is a .168. So it wasn't like you had a few beers the night before and you decided to get in the car. You were super drunk. You were twice the legal limit, according to the blood draw. But I'm not gonna take your plea. If you think you have a defense, I didn't hear one, but maybe you think you have one, you have a right to a trial. Let's go to trial next week. And you can let a jury decide if you forgetting you were drunk when you got in the car and operated a motor vehicle on a public roadway. Like, you've given me all of the elements to finding you guilty.
All right, I am guilty. I am guilty,
No,
Your
I
Honor.
mean,
It's a bit late for that now. For the judge to accept your guilty plea, it has to be knowing and voluntary. If you believe mitigating circumstances mean you don't meet the elements of the charge, then you can't plead guilty, and your only option is to take it to trial.
I don't understand what you're saying when you say you don't feel like you're guilty, though. What part of it doesn't feel guilty to you? I'm being honest, Mr. McLean.
I'm being
Like, I
honest.
understand.
I was abruptly woken up and I was not thinking straight. I was more concerned about my family than I was everything else at the time. I'm the only person that takes care of my children for the last 3.5 years. I am a single father and I am doing everything I can to take care of them. And yes, I was drunk, but yes, I did forget that I was drunk at the time.
Mr. Gazicki, have fun with this one. All right, we're going to jury trial.
All right.
I'll plead guilty. Yes, I was guilty. That's what it is, and that's where it stands.
I mean, what am I supposed to do with this, Mr. Gazicki?
Can I just ask one question, Your Honor?
Go ahead.
Mr. McLean, do you dispute the lab results that you had a .168 blood alcohol
I'm not
content?
disputing that.
Pardon?
I will plead guilty. Yes, I was. I was intoxicated at the time. Yes.
So I'm asking you, do you agree with the lab report that you had a .168 alcohol in your blood system?
Yes, I do. I cannot deny that.
Your Honor,
So,
that's
I mean, here's the problem, Mr. Gazicki. It's not whether or not the elements have been met. They clearly have. It's that the plea has to be knowing and voluntarily.
Right.
And he's told me he's not really willingly pleading. So the plea's not voluntary.
okay.
I mean, Mr. McLean, that's the issue. Do you understand that? I can't accept a plea of guilty if you're not willingly pleading guilty. That's what the law requires.
I don't feel I was, but yes, I was. So I don't know how to describe
Okay,
this.
we're
and I
done.
don't know how to
All right, thank you. We will see you on your jury trial on November 7th of 25 at 8:30 a.m. in person at the 23rd District Court, okay? We'll just proceed to trial. That I'm not making a determination. I'm not taking a plea if it's not voluntary. So you're all set, Mr. McLean? Your bond continues. I'll see you next week. All right.
Okay.
All right. So it looks like we'll be seeing this guy again in November for his jury trial. Maybe he can convince the jury that forgetting he was drunk means he shouldn't be held responsible for his actions. Now, switching gears to Florida, we've got a dangerous Florida man charged with attempted murder who somehow thinks he is a victim.
All right, Mr. Ladson with Mr. Riosti. Oh, and
Is anyone here from Mr. Ladson's family? Were you hoping to make a statement? No. Joseph Riossi for Michael Allen Ladson, who's present before the court in 2022 CF 827, Your Honor. This case is set for sentencing after jury trial for both the possession charge and the attempted murder charge, where he was found guilty by a jury of his peers. This case had been previously set for sentencing, and the PSI had not been adequately completed. It's been since then it's been completed and presented to the court. Mr. Ladson has a copy of the PSI, and I've gone over it with him. And we're present to proceed to sentencing.
all right, any additions, deletions, or alterations?
No, Your Honor.
I need to speak. I put in for Nelson here, and I've been trying to get him to quit, to take himself off of my case, and he keeps refusing to do it. So I filed for a Nelson hearing. He's been telling me that he was filing. He told me the day we did the last when y'all found me guilty, the day y'all found me guilty the second time on the second charge, he told me that he was going to come see me the next day and we would file an appeal. He keeps lying to me and telling me that he's got to wait until after I'm sentenced, and all he can sentence is the sentence. He's saying he can't appeal the verdict or whatnot. But also, I want to mention, I know that's one thing, but I'd also like to mention this here. You may not remember when we sat in here, me and him were sitting here at this table, and you asked Gomez, well, what are these carrying, or what are we doing when we come in here? The last time to prepare, right before, prior to trial, to the possession charge, and he said 3 to 5, and what, 5 to 10, you said? And you remember telling him on a couple of different occasions that there's no min man?
No,
And you don't remember that?
I explicitly did not tell him that.
Well, the trials happen, now we're sentencing. The Nelson is tardy since the trial has happened. As to the appeal, the case really isn't finished until the sentencing is concluded. So the period of time to appeal has not begun until the sentence is imposed.
But isn't his job necessary? Isn't it truly done? I mean, once I'm sentenced, he's not really going to be worried about fooling with me anymore, right?
Well,
But I'd also like to mention, like I said, I haven't been able to get him. You know yourself, you've been trying to get me to fire him, and I just hadn't done it. Just trying to go along with the court. It seemed like you've been questioning me, making sure I knew what he was doing. But how is it that they found me? I believe that the questionnaire was wrong because they asked. It's obvious you can't charge somebody with attempted murder after the police reports clearly states there's 3 or 4 earlier altercations. That's attempted manslaughter. I mean, I've been reading up on this. I've been looking.
Well,
I know how the law works anyway. It's 77 what -4 or whatever the numbers are.
Clearly, you don't understand how the law works. Attempted manslaughter involves a heat-of-the-moment act showing reckless disregard for life. But you got into the altercation, left, went and got a firearm, then came back to finish the fight. Those actions show clear premeditation, which is why you're facing an attempted murder charge.
yes, sir. Well, that issue is gone. The jury has found you guilty of those charges. And if you believe those were incorrect, then that would be something for the appeal. But you can't get to the appeal until the sentence is imposed.
So there's no way right now y'all can't just back down to attempted manslaughter, make this something reasonable. I've got children out there, I've got responsibilities out there. I can't just go. I didn't even speak at the trial. Y'all didn't allow the depots to be used. Y'all didn't allow the police report to be used. And these are all things that are part of the police investigation. These aren't like, and then the two, my attorney never did enter the two negative GSR reports that were put in with the two, with the major fingerprints. What happened to them tests?
Yes, sir.
And why can't I get y'all to provide them?
Yes, sir, those may be issues for some other circumstance, but they're not for today. Today, we're here for sentencing.
I haven't even been to a pre-sentencing investigation. When is that?
Well, you've got the pre-sentencing investigation.
This is all made up stuff. There was one guy come to see me in the jail the other day, but all he asked me was my family's phone numbers, and that's all he asked me, and he left.
Yes, sir. Well, I have the pre-sentence investigation that's been provided, and I guess technically you really didn't, a pre-sentence investigation wasn't required considering your prior history, but I ordered it anyway, and so now we have it, and we're here today for sentencing. So those sounds like all issues that you can take up in an appeal, and you're welcome to do so. And you've heard me say it many times. I have no personal investment in how it goes anyway. If I made a mistake, I'm happy that the people in Tallahassee will correct me.
The last time we was in here before the possession charge, was all that recorded?
Yes, sir. All our proceedings are recorded.
And I've explained, for the record, I explained to Mr. Latson that when I filed my notice of appeal, after the court enters its sentence, I will be asking for multiple for the transcription of multiple court proceedings, not just the jury trials, but the preceding, a few of the preceding hearings, and then the sentencing hearing and any other hearings in between.
All right. State wish to proceed.
Yes, Your Honor.
Go ahead.
Your Honor, we're here to sentence Mr. Latson on 2 counts, one of them being attempted second-degree murder with a firearm, and the second being a possession of a weapon by a convicted felon. With respect to count 1 of that, the exposure is life. This is a 1020 life statute. We proceed under the 1020 life statute. The jury found Mr. Latson guilty of attempted second-degree murder, but then further found the required 3 findings: that he committed it while possessing a firearm, that he actually discharged that firearm, and that he caused great bodily harm to the victim by discharging that firearm. The facts of this incident, I'm not going to harp on them, but just to be brief, this incident was where the defendant had a run-in with the victim and his friends. He was told to leave the premises. About an hour went past, and Mr. Latson chose to go and get a firearm, to load that firearm, bring a loaded firearm into a public building, and discharge that firearm. I think we are extremely lucky that the defendant, or the victim rather, did not die that night.
Then why did he fire the gun? And honestly, as much as a defense attorney is trying to soften the circumstances for sentencing, claiming that if he hadn't been punched while trying to kill someone, he might have succeeded is a pretty weak argument. That said, I don't blame the public defender. He's doing the best he can with almost no resources.
Given the individual or the defendant's status as a convicted felon, count 2 is going to carry with it a mandatory minimum sentence of 3 years. Given the potential exposure, I believe the minimum guidelines shows 272.55 months in the Department of Corrections. This is a 25-year mandatory minimum because of count 1. On count 1, there's 25-year mandatory minimum. We do feel as though, even still, the defendant is showing absolutely no remorse for the actions that he took that night. He is still trying to find every little possible way out of facing accountability and responsibility for those actions. Your Honor, because of this, we are respectfully requesting 40 years on count 1, 25 years of it being a mandatory minimum sentence. And then we are requesting 15 years as to count 2, with 3 years of it being a mandatory minimum sentence. Those would run concurrently, Your Honor.
Mr. Riosty.
Your Honor, Mr. Ladson, we never really went into the proceeding, what happened prior to that, because the victim had passed away from unrelated issues. If he was able to take the stand, we would have been able to discuss some of the preceding events that had occurred. In mitigation, the victim, there were a number of arguments prior to Mr. Ladson entering the bar. They occurred at other bars. And during the evening, and at one point he was pushed down on the sidewalk in front of chasers. It's certainly not a justification for entering a bar and discharging a firearm. They shoved him down on the pavement outside. The testimony at trial, he entered the bar and pointed the gun at the victim, and there was inconclusive testimony as to whether he was struck in the face prior to discharging the firearm, or the firearm was discharged at the same time. So it's possible that Mr. Ladson was just going to angrily assault the victim. It certainly is possible that when the gun was discharged, that the victim might have been shot in a more egregious location. The state had argued at sentencing that it was in their final argument at trial that but for him striking Mr. Ladson in the face, he might have been shot more fatally, basically. But it's a possibility that that Mr. Ladson's purpose wasn't necessarily to fire the weapon.
Well, life's not fair, especially when you choose to be a lifelong degenerate criminal. But now it's time to wrap up this mess and send him off to his new home for the next 25 to 40 years.
And I'd ask the court to consider that in sentencing. 25 years is a significant sentence. The court has entered a sentence today on felony murder where 2 victims were deceased in a plea agreement for 25 years. And I think in this case, where the victim was injured, that a 25-year sentence is just and appropriate. So I ask the court to sentence Mr. Ladson to the 25-year minimum mandatory sentence and run all the rest of the sentences concurrent with that.
I'd like to say one more thing. I didn't testify myself. I figured just the physical evidence alone would take care of everything itself, just because the physical evidence did not point to me having a gun or firing one. But I didn't even have a gun that night. We got in a fight over the gun because they come over him when we was fighting. They come over him and tried to shoot me. I was trying to take possession of the gun, and that's why I keep bringing up the fingerprints, because there would have been 7 or 8 different fingerprints on that gun. So, I mean, I understand you saying that you can't make any special accommodations, but is there not a way can I not claim a mistrial or something? There's got to be something I could do, right? I mean, I don't understand how I can just be left here hanging. There's got to be something. And I've got money on the streets. I've got a trust fund. I could get my own attorney. I looked in. I looked in through the jail to get them to get me like a caseworker or whatever, so I could, take care of finances or whatever on the streets, since I don't have anybody to help me out. And they told me they don't offer them services.
Anything further on your sentencing arguments?
Nothing from the state, Your Honor.
Nothing from the defense, Your Honor.
Well, and I understand your argument about, sentences and consistency. What's the difference between this case and the case that I just issued a 25-year sentence on? What's the difference between that case and this case?
I mean, the defendant entered a plea. He
With agreed upon sentence with the state, right?
Yes. It wasn't agreed upon then.
And so I don't accept every plea offer I get, but when there is agreements, generally that's the situation. So that's a...
For the record, Your Honor, my comparison was more in the fact that there were two bodies in that sentence, and there are no bodies in this case. Mr. Meeks was shot and wounded, but he recovered, and that's the gist of my argument with regard to the 25 years as a significant sentence and appropriate for a scenario where there's no one suffered a fatality.
And how is it, Your Honor, like, I've got, my siblings went to school with a fellow named Donnie here a couple of years ago, shot 4 people, and he did 4 years, and admitted to it, and got 4 years, he did 4 years to the day. How is it that y'all are gonna hit me with 25 years? It's not fair. I mean, I don't know the boy's last name, but it's definitely not fair to you.
Well, there you have it. 25 years minimum, possibly up to 40. And it's not because Florida's feeling generous. The moment a previously convicted felon grabs a gun, the law basically says, congratulations, you've unlocked the no parole level of life. This guy didn't just lose control. He argued, left, grabbed a gun, and came back shooting. That's not heat of passion. That's attempted murder. If you liked the video, hit the like button. If you didn't, hit dislike. But don't forget to leave a comment below and subscribe with notifications on so you never miss any of my content.